for attending this webinar, which is part of our Road to BVI Arbitration Week. I know for quite a few of you, you're approaching happy hour on a Friday, so we're really grateful that you've taken the time to join us today. My name is Shan Greer, and I am the CEO of the BVI International Arbitration Centre, which is an independent non-for-profit institution established to meet the demands of the international business community for reliable dispute resolution. Our mission is to become the go-to institution for international arbitration in the Caribbean, Americas, and beyond. At present, the BVI Arbitration Centre is serving as a center point or fulcrum for dispute resolution, thought leadership, some seminars and training, as well as other initiatives within the Caribbean region, with the intention to expand through the Americas and worldwide. Since my appointment in January of this year, our goal is to create strategic relationships between other institutions and organizations in our region with the view to improving the promotion and delivery of arbitration services. So with this in mind, I'm very delighted to announce our collaboration with the Silicon Valley Arbitration and Mediation Centre, who today is represented by its CEO, Sarah Reynolds. Sarah is the managing partner of Goldman Ismail Thomaselli Brennan and Baum. She acts as an arbitrator and represents technology and pharmaceutical companies before domestic and international arbitration bodies. Her disputes range from complex commercial supply agreements to IP licensing and technology development agreements. Sarah's arbitration experience also includes obtaining and defending against judicial review of arbitration awards and drafting and reviewing arbitration clauses in enterprise critical transaction agreements. So well placed to be contributing to the subject matter today. Now, earlier this year, we announced that next year, the Centre will be hosting its 5th BVI Arbitration Week on the week of the 11th to the 15th of March. And our focus is on delivering arbitration services to the industries critical to the Caribbean economy. And there are a few industries which fall into that category, some of the more obvious ones like construction, oil and gas, and renewable energy. But certainly an emerging industry is FinTech. And it's our hope that we're going to be attracting thought leaders worldwide in the industry. And we're very excited about that. Now, after we announced our date in Arbitration Week, we quickly realized that it conflicted with California Arbitration Week. And that's becoming a more common occurrence because, of course, there's so many arbitration weeks worldwide. And so we are so grateful that once we realized that there was going to be this clash, as it were, that Sarah and the other organizer of California Arbitration Week agreed to take a collaborative approach with us. So we realized that FinTech is an area that connects both our centers and regions. And so this collaboration is just a part of the many initiatives that we're going to be running together. We're going to be signing a memorandum of agreement today to crystallize the relationship. And then during our respective arbitration weeks, we'll also be hosting events collaboratively. And certainly that's the ethos of our center, to work with those around us. And I don't think I speak out of turn in saying it's the same for Sarah and her organization as well. So I'm going to hand over to Sarah, who's going to tell you a little bit about the Silicon Valley Arbitration and Mediation Center, as well as California Arbitration Week. Sarah?
Thank you, Shannon. Thank you so much for having us here today. It's such a pleasure. And it's been great to take what was a calendar clash and turn it into an opportunity for collaboration, which really speaks to the heart of the MOU that we're looking to execute today. Just for a bit of background, the Silicon Valley Arbitration and Mediation Center is a nonprofit that was founded in Palo Alto, California, but really serves the global technology sector. And I'm thrilled that you have the founding member of Silicon Valley is with us today, Gary Benton. We'll hear more from him later. But SVAMC, unlike your organization, Shan, we don't actually administer cases, but rather we promote efficient technology dispute resolution and advocate for advancing the use of arbitration and mediation and technology-related business disputes around the world, and that includes FinTech. So we're thrilled to be here today. And yes, concurrent with BVI's arbitration week, there 52 weeks apparently are not enough weeks in the year any longer to accommodate the international arbitration community. But the California Lawyers Association and California Arbitration are hosting the 3rd annual California International Arbitration Week. It'll be held March 2024, the week of March 11th, so the 11th to the 14th. And it'll be in San Francisco this year. Last year it was in Southern California and Los Angeles, but we're thrilled to bring it back to the Bay. And it'll be hosted at the Hyatt Regency in San Francisco that week. And we encourage you all to participate. If you can't join us live, there will likely be at least several web-based programs that you can participate in remotely. And we look forward to seeing many of you there.
Thank you, Sarah. So the memorandum of understanding that we're signing is not just limited to the promotion of arbitration, but it'll also be looking to strive to find other ways in which we can work together to deliver arbitration services. And so certainly you'll be hearing more about some of the collaborative initiatives that we plan to host together. And so with that, Sarah, I'll invite you to sign your side of the MOU, and then after that, I'll do the same. All right, so now that we have the protocols out of the way, we have an exciting discussion for you about FinTech, both in the Caribbean and the Americas. And so I'm going to ask Sarah if she can introduce our speakers.
I'm happy to do that. Thank you. We have a great group for you today. I'll start with Gary Benton, who is our Silicon Valley representative. So Gary is based in California, and he is an internationally recognized arbitrator with expertise in the United States and internationally. He deals with corporate investment, technology, IP, and emerging growth matters, including FinTech and crypto. And among many other prominent roles in the international arbitration community, Gary is also the chairman of the Silicon Valley Arbitration and Mediation Center board. So we're thrilled to have Gary here today with us. And then from Barbados, we have Tara Frater. Tara is the principal and founder of FT Legal. Her practice areas include corporate and commercial, finance, FinTech, securities regulations, trust and estates planning, immigration, and real estate. Tara actively engages on issues affecting the international financial service sector in the Caribbean. She participates in various working groups focused on legislative reform and currently serves on the FinTech Advisory Committee and the Trust Review Committee for the Barbados government. And last but not least, we have Mark Forte, who is our local BVI representative. Mark is managing partner and head of litigation and restructuring at Conyers in their BVI office. He specializes in complex commercial litigation and contentious cross-border insolvency. Mark also regularly advises foreign states on international asset tracing measures, and he has appeared as an expert witness in investment treaty arbitrations before ICSID, among other tribunals. So welcome to all of our panelists. We look forward to all the insights you'll share with us today.
Thanks, Sarah. I think it would be remiss of me not to mention that Mark is also one of the board members of the BVI International Arbitration Centre. So we're going to first talk about the nature of the use of FinTech. And I think it's fair to say that, relatively speaking, FinTech is a new industry, and it's had worldwide implications, including for America and the Caribbean, particularly as it relates to dispute resolution for cryptocurrency disputes. Certainly from our center's perspective, we've had our fair share of fintech related disputes, particularly crypto. And so I know this is an area that a lot of people want to understand. They want to know what's happening, what are the emerging trends. And Gary, I wanted to get your perspective on some of the emerging trends as far as you see it in the use of in the use of dispute resolution clauses in crypto contracts. What is it that you're seeing? Is it fair to say that the cryptocurrency industry tends to lean towards arbitration, or maybe even a fintech in general, or they're more court-based? Tell us a little bit about what your experience has been.
Sure, the answer is yes, but before I elaborate on that, Shan, let me first of all thank you and the Center and SVAMC and all of our colleagues at BVI in the Caribbean for having us here and doing this program. To put this in perspective, as you all know, fintech essentially involves new technologies for delivery of financial services. And when we talk about fintech, we're really talking about four very broad areas of technology. Artificial intelligence is one, blockchain, including crypto, is two, cloud computing is three, and big data is four. So we call those the ABCD of fintech. And of course, we've all used fintech. I mean, we all have our smartphones and we do online banking with them. We do investing. Undoubtedly, many people on this call have already played around with cryptocurrency, perhaps some quite a bit. And we all use fintech payment applications like Stripe and PayPal, Venmo. So fintech is really here with us, and it's really exciting in terms of the opportunities that we're seeing with it. Crypto has really caught a lot of attention over the past couple of years, and it's going to continue to do so despite the up and downs in the market, despite some of the regulatory issues that we've seen in the US. But AI as well is going to really make a big difference. In terms of where it's being handled in dispute resolution, the answer is really all over. I did a survey that I updated just a while back on some of the bigger companies and where they are handling their dispute resolution cases. And it's all over the world, really, but you do find it in the leading arbitral centers and regional arbitral centers. So places like Hong Kong in the past, now more likely you'll see more in Singapore, in the US, of course. In Switzerland, there's been some. And BVI is really up and coming in terms of a location that has and is going to continue to see, I think, quite a number of crypto disputes.
Thanks, Gary. And Tara, from a Caribbean perspective, can you share some of the emerging trends with respect to the use of dispute resolution clauses in crypto contracts? And are there any challenges that you think users should keep in mind?
Yes, thank you so much, Shan. I'm delighted to be here and to be participating in this discussion with this esteemed panel. So I think that what we are seeing in terms of, or what I'm seeing in my practice in terms of fintech and crypto entrepreneurs in particular, using arbitration clauses is, whatever it can be the subject of a contract will be open to be arbitrated. So to the extent that we're seeing an increasing move towards the adoption of arbitration generally, and people being more open to the use of arbitration and appreciating the benefits of an expedited, cost-effective and efficient dispute resolution mechanism, we're seeing that reflected also in the crypto space. I'm seeing that emerge commonly in disputes or in contracts relating to token sales, in SaaS, in contracts, relating to developers or with intellectual property, because entrepreneurs are increasingly becoming astute to the fact that no one wants to be tied up in a very lengthy, time-consuming process through the court system, and they are appreciating the benefits that arbitration can bring to resolving those sorts of disputes. So you're generally seeing that trend, but particularly in disputes or issues relating to token sale agreements or with developers, at least is what I'm actually seeing. In terms of some of the challenges with pursuing arbitration, or using arbitration as a dispute resolution mechanism. There is a concern as to, the uncertainty in the regulatory frameworks, because, for example, some jurisdictions have banned crypto assets or heavily regulated their use. And there is a justifiable concern as to, if crypto arbitration is seated in one of those jurisdictions, whether if enforcement of an award is sought there, whether it is going to be allowed from a public policy perspective. There are other challenges that relate to, for example, the nature of the technology, it, being very complex, and ensuring that, the arbitrators that you actually use in that process have sufficient technical expertise. So not just expertise in the procedures relating to arbitration, but actual subject matter expertise, so as to be able to resolve the disputes effectively. So there's also the question of the lack of precedent around these issues, which bedevils the courts as well. But it's also an issue that will arise in this context where one is looking to arbitrate issues. So, we have a very interesting and challenging dynamic confluence of factors that make arbitration increasingly attractive to entrepreneurs in the space, but also add to the difficulty of having resort to arbitration as a dispute resolution mechanism.
Yeah, no, certainly. I think you make some valid points. And Gary, from your perspective, from an America International perspective, do you see similar issues or similar trends with respect to the types of disputes that are going to arbitration in the fintech world?
Yeah, I think Tara's exactly right. It ranges all the way from consumer disputes to disputes involving crypto companies and their acquisition of goods, their acquisition of services, disputes over AI. It really varies, quite a bit. To Tara's point about regulation, I mean, she's absolutely right. I mean, there's just, so many different approaches around the world, ranging from China absolutely outlawing crypto to countries like the US, where we're trying to figure out what the regulation is all about, to other jurisdictions where it's really very warmly welcomed. I mean, the largest use of crypto in the world right now is in India. So, there have been very different approaches all around. There was an amazing article just yesterday in the Wall Street Journal that I think summed up quite well the US problem. And it said that crypto is still the Wild West of finance. And, putting that in BVI perspective, it's like the golden age of piracy and Tales of Black Bureau again. And what that means is really, there are large companies, there are small companies, but in the US, we just haven't figured out whether and how it should be regulated. And, you read the headlines about FTX and the Sam Bankman-Fried trial, FTX being a Bahamas-based exchange. And look, there's no doubt, I mean, that there have been problems with crypto in terms of fraud and worse. And yet financial tech offers so many benefits in so many other ways and is used by big companies to great advantage. And the US courts and Congress have just been divided over how to deal with it. They can't figure out whether it's a securities or a commodity. They've had some, the SEC has had some major problems in terms of regulation. The Ripple case, there are now cases involving Coinbase, cases involving Binance, and we'll see how those turn out. But it is very much an evolving scenario. And the welcoming that I think you see from BVI and other Caribbean jurisdictions is a plus. And I think crypto companies who are developing amazing products really appreciate that.
Thanks, Gary. So I'm going to hand over to Sarah now, who's going to get more into the nuts and bolts of the types of clauses or terms and conditions we're seeing in crypto-related contracts, and what are some issues that are arising from a dispute perspective.
Thanks, Shan. I appreciate that. So we want to move on to talking about sort of the interplay of arbitration clauses and crypto-related contracts, and particularly sort of the terms and conditions that we're seeing there. Mark, I'd be interested to hear your perspective on sort of the choice of dispute resolution clauses that you're seeing in crypto-related contracts. I assume most of these are in the consumer crypto industry context, but would be interested to see what you're seeing in your practice.
So I think it's useful. Thank you very much, by the way, for the opportunity to speak. Nice to see everybody. I think it's very useful to get a little bit of context that, if we concentrate on crypto for the moment, there's no coincidence that the offshore sector has been attractive for the crypto industry, right? In terms of allowing a freedom of regulation. But so too, where the sophistication of regulation in places like the United States is perceived to be a great center of commerce, etc., so too it attracts an uncertainty because it attracts a great deal of debate and legislation. And with uncertainty, shies away the market, right? And one of the great nature and advantages of very well-established incorporation centres like the British Virgin Islands, Cayman, Bahamas to an extent, is that they are designed and have for many years been built on flexibility of sophisticated corporate models. So they're joint venture or holding structures. People come here because they don't want to be in the US or China. They want to be collaborating in a neutral, sophisticated, enforceable jurisdiction that has good courts, that ends up in an appeal somewhere in London or Paris or whatever it is, if it's an arbitration clause. So the context of places like the BVIs, there's some very well-known household names in the crypto industry that incorporate in this jurisdiction. Now, where the rubber hits the road in terms of the type of clause you get to govern disputes, in the crypto business, by its nature, it appeals to the mass public online with ease and access. You want to buy a bit of Bitcoin, you go online, away you go, tap in, off you go. There are millions and millions of contracts every time you buy something, right? And so the question is, how do those contractual clauses get addressed? How do they get incorporated as terms and conditions? And we know that if we look at two main areas of contract activity, B2B, B2C, business investment into forming the platform or the crypto industry. That's an investor, 2, 3 investors, very traditional shareholders agreement, investment agreement, one-on-one, lawyers all over the place, negotiating out a sophisticated dispute resolution clause. Although frankly, I'd be out of a job if there wasn't unsophisticated resolution clauses, as there really are in billion-dollar contracts. But those are the guys who all lawyer up, they know what they're doing, and they negotiate something out. The consumer side of things are the million other guys who are buying the Bitcoin. They tick the box before they can execute the payment. They've never read the terms, right? And if they do read the terms, what are they going to do about it? They're not going to write back and say, I don't like clause 3.6. They're not going to get their Bitcoin. So it's your classic uneven bargaining power, but that's the nature of consumer. With the nature of consumer comes the need for consumer protection, right? And so many countries legislate consumer protection in so many different ways. And one of the classic examples, and one of the, if you like, one of the more recent and more informative cases of this out of the UK has been a failure to enforce because the standard term US jurisdiction clause to a consumer contract breached UK consumer law. And as such, that was unenforceable. And so the contract goes. Now, what we're seeing is the demand and the perception and expectation of the consumers in the marketplace, in the crypto industry, where people are buying in their basement, they're buying on the way to work, they're buying on their cell phones. Speed, as Tara said, speed, access to justice, right? And the ability to get whatever they can get quickly resolved. Get it. They don't want lawyers, they don't want judges, they don't want wigs, they want an answer, right? And that's where it comes together. How do you perform and match that expectation in a way that makes credible sense to get what it is that you're wanting to get? You can't necessarily match quick, speedy justice with enforceability at the end of the day. You can if you do it carefully, right? But that is, as Gary says, that's the evolving nature of this jurisprudence, right? it is not tested very well. It is, people are running enforcement defenses all over the world, right? And as people will understand, there's a treaty about enforcing, right? States sign up to the New York Convention in this case. They sign up on a treaty basis that we will not respect on certain bases, certain awards for arbitration across the world. And so therefore, the terms and conditions from the very start that you get involved in may end up with something that you can't take to where you need to take. And that's one of the problems that needs to play out a little bit more. So we're not seeing a large amount of what we call sort of public interest or arbitrability, public defenses to enforcement, because they haven't really flushed through yet. They're not big enough yet. But what we are seeing is in the crypto industry, where there's a blip or a solvency issue and we hit insolvency or bankruptcy in US terminology, that has started to be in the domestic jurisdiction like the BVI. So currently in the BVI, we have the 3 hours insolvency. Gary related to FTX, which was a Bahamian insolvency, is now taken over by Chapter 11. But in FTX, that famous little company called Alameda, which had a little 9 billion parked in it, that's a BVI company. Right? So it's another example of jurisdictions all over the place, terms and conditions all over the place. And what we're seeing is the beginning of the process to flush them out and start to maybe pay a little bit more attention to what you're signing up to.
And if I may, I'd just like to add something to what Mark said in that context about terms and conditions. It's very, very interesting. One thinks about the disparity in bargaining power, and that you really don't have an option, so you just click yes. But have you actually really agreed to this? And even if those terms and conditions actually have or resort to arbitration as a dispute resolution mechanism, there can be challenges for consumers seeking to rely on those arbitration clauses, because I'm thinking of one exchange in particular where their user terms actually refer to the agreement being between the user, the end consumer user, and that exchange's operators as it was defined. And that open-ended definition included, but wasn't limited to, legal persons, unincorporated organizations, and teams that provide services that are responsible for such services. And so therefore, when a dispute arises, it creates a real challenge and a real difficulty for a consumer, for example, who may want to rely on that arbitration clause to actually identify the correct counterparty for the arbitration. So, there are some challenges that I think arise in the context of the use of arbitration that stem not from arbitration itself, but from how players may use arbitration and the hurdles that they may create or set up in the context of B2C engagements.
Yeah, and we are struggling with many of the same issues here in the United States with business to consumer arbitrations, essentially replacing class actions, and a lot of companies regretting the terms that they had included in those clauses, because they've essentially been weaponized now by plaintiffs' firms, where many of the businesses, in order to make the clause fair, agree to pay the arbitration fees, which in many of these instances are higher value than the underlying merit, the underlying claim. And so when aggregated, it can be quite a significant amount of liability. And I think many of the consumer-focused fintech companies, I'm sure, are using similar clauses and reevaluating them here as well.
Interesting you said that, because one of the inherent problems with arbitration, which again can be got over depending on the party's approach, is that it's confidential, right? And the establishment of precedent and understanding what's going on in various different arbitration and the arguments that are being raised in arbitration, and knowing what those arguments are, and are they winning, and are they having effect? By their nature, they tend to be confidential. They're not all confidential, but they tend to be. And so getting to hear, getting to understand, and getting to deploy those arguments, is done anonymously and through the legal industry mainly. but it's not like looking up a judgment on a website.
And definitely that, that privacy that we find in arbitration, has its pros and cons. I think companies, tend to like that, because they can keep cases separate. And as Sarah said, I mean, in the US, we had this rather unique phenomenon around the world of these class actions in courts. And the courts have allowed arbitrations where class action can be excluded. So that's I think a big incentive. But I think it really goes back to what Tara was saying at the beginning. The biggest incentive for arbitration is really the concept of this expedition, cost efficiency, time efficiency, just being able to resolve disputes quickly, which both sides of a transaction always want.
And just to follow on the consumer protections and arbitration theme here, Gary or Mark or Tara, would any of you like to comment on the effect of the recent Payward case?
I can get started, or Mark, Tara, if you want to.
Help yourself. I'm sure you.
Go ahead.
So, it's really
the elephant in the consumer arbitration room.
Yeah. Well, Mark, you hinted at it already. So I'm actually going to pronounce the name of it: the Payward versus Cheketkin case. Try to say that 10 times fast. So this was a case brought by an English consumer against the Payward Group, which does business as you all commonly know as Kraken, the big crypto exchange in the U.S. And Mr. Cheketkin, wanted to reclaim some 600,000 pounds of losses on positions that he made on the Kraken exchange. And his problem was that the arbitration agreement, the user agreement for Kraken, provided for California arbitration, California law in California. And he wanted the arbitrator in California to consider UK consumer and financial services law. And the arbitrator said, no, I mean, your contract is clear. Your contract says California law. And so after he lost, he brought his case in England. And Kraken in England tried to forestall the case by saying, look, we already have an arbitration award in the US. And the English commercial court just wasn't buying that. And the bottom line is the court said, look, consumers in the UK are entitled to protection under the Consumer Rights Act, under the Financial Services and Markets Act. And therefore, this award violates public policy and it's not going to be honored in England. Now, that, as Mark said, the New York Convention, this treaty essentially signed by over 170 countries around the world, is famous for being so strong about protecting enforcement of international agreements, arbitration agreements, and international arbitration awards. But there is, as part of it, this public policy exception, pretty narrow, pretty infrequently used, but very important, that says that if an award violates public policy, it won't be enforced. And that's what we have to make of it. The English court, wasn't too kind on the U.S. arbitrator. The U.S. arbitrator probably did a fair job honoring what the agreement said, but it is mandatory law in England to protect consumers in this way. And so that's, the outcome of the case. And I think my take on it is, we're going to be seeing more of this in terms of protection from England and the UK on consumer rights. And what it means is we just have to have more careful drafting of agreements in terms of dispute resolution. So that's my quick take on it.
I'll just briefly add to that, which is, as you said, the arbitrator, one of the problems with the case, and it might have made a bit of difference, but the arbitrator refused to listen to submissions that English law would not allow this arbitration to be enforced, right? The arbitrability of it effectively. And the English court commented on that. Whether the arbitrator had listened to it and said, I've heard what you said, but I'm still going ahead, might have led to some more sympathy in the UK, but I still think ultimately it's an enforcement public policy argument. there's not enough protection for the consumer. Interestingly, we don't have the same level of consumer protection in the BVI, right? And so other jurisdictions, and England's certainly not alone. In fact, it's quite normal in the European community to have consumer protection, some countries much more than others. So I suspect it would be significantly broader than just the UK in terms of that sort of consumer argument. But this is how you learn, right? This is next time you pay more attention to what your clause is and how you expect to be able to enforce that. But the one lesson from it, or the one point I think practice experience tells me that I would say, the Article 5 treaty defences to enforcement, the industry clearly recognises, and as we see the emergence of litigation finance, those are people who invest in claims in order to take claims off the hands or fund the claims to bring arbitrations or judgments. In arbitrations, the first question any litigation financier is going to ask you is, can I enforce that? Right? Or what's the route to enforce it? Because, as I suspect we'll all agree, getting your award is one cost. Enforcing it can be 2, 3, 4, 5 years potentially in the court system, because it turns to court and you run these arguments. You can get routes to expedite, but expedition is a year, right? So it can cost more to enforce than it can to get the ruling in the first place. That's not every case, but it is a factor. And I think countries are paying more attention to the need to change that.
I think that's exactly right. I mean, this payword cracking case is really a narrow, exception, dealing with consumers in the UK, in England in particular. But as you said, there's no question the main advantage of international arbitration is that it is multinational. You resolve disputes involving different jurisdictions around the world in an efficient way, and you can have awards that are enforced around the world. And that doesn't work with court judgments. Court judgments are pretty limited in their, where they'll be enforced. International arbitration awards, you can take it to all of those 170 plus New York Convention countries.
Not to the UK though.
On those little consumer cases, that's right. Not to the UK, unless you provide for arbitration in England, which nothing wrong with that as well.
Nothing wrong with that either.
Well, I always feel compelled to make sure everybody understands the clear distinction between business to business arbitration and business to consumer. And while the consumer context may be fraught with some of these uncertainties and issues, we really don't see similar parallel issues in the business to business context. So at least that arena remains safe. But I do, it is sort of a fraud area these days, and maybe becoming more so rather than less so in the short term. But so what are companies who are, selling, whether it's access to a platform or, in the fintech context, companies that are sort of selling globally to consumers, what are they to do? What in terms of the actual terms and conditions and the arbitration clauses that are in those types of agreements? What are you seeing in terms of, seats, rules and are you seeing any sort of any sort of things arising?
So let me just comment on one thing that I haven't seen, but I've heard a lot about, and I suspect Gary probably more likely to have seen it, or Tara, is the notion of building in the enforcement to the actual terms, right? And so you empower the tribunal to execute the enforcement. And that can be, for example, a wallet address, right? There's a dispute. It goes to a nominated expert, person who knows all about wallets, much more than I would ever do. And at the end of it, they say, okay, we've all lived by the procedure. The result is you get the key. Here's the key, right? Now, the problem with that is, what if that's successfully challenged, right? Yeah. And you come back to an enforcement measure of, how do I enforce a challenge to that if I succeed? Now, you don't shut out a challenge. You can't ever shut out a challenge completely. You can shut out appeals and points of law, right? Which is, scary enough, but you can do it, right? But the idea that you find out afterwards, in extreme case, that there's bias or something, extreme like that, it's done. It's enforced. You don't have the hurdle to say, stop the enforcement on this ground. I want a hearing to determine whether that was procedurally irregular or, public interest, whatever, something like that. Interestingly, of course, the treaty defences, what are known as the Article 5 defences, get lifted into domestic arbitration legislation in the countries around the world. In the BVI, they've added a defence, which is where it's just and equitable. Right? Now, that isn't in the treaty. Right? Public interest is in the treaty, but a just and equitable basis for not enforcing throws the door wide open to arguments such as we get them all the time in a basis to appoint a trustee or liquidator when it's just an equitable, it's just the right thing to do. So if you have execution built in to the process, it's fantastically speedy, I would have thought. It's also, I think, a little bit of Russian roulette, in the sense that, you can't pull back the bullet, right? What do you do about that? I don't think there's an answer to that. And I think, I don't know, I've never seen it played out or enforcement. Interested if anybody else has. But that is one factor of trying to speed things up. I think it's relatively risky, but effective.
Mark, that's really interesting. I think it's very jurisdiction specific, and I have not seen it in the US. I think partly because we have a process for confirmation of vacature of awards. But what you're reminding me of is, when I first started looking at this area when it was getting going 10 or 15 years ago, there were all these companies that were crypto companies that were trying to do their own self-regulation, right? Where they would put together their own dispute resolution. And that's actually evolved. Now there are, what are called on-chain systems, companies like Claros and CodeLegit and Aragon that are, they're cryptocurrency companies, basically. They're cyber blockchain companies that are resolving disputes. But I think with most of what I'm seeing now with the traditional institutions, it has been pretty separate in terms of implementing the actual enforcement. But it's an intriguing topic. You perked my interest. I'm going to look into that some more after this.
Yeah, it'll be interesting to see if it takes. Have you guys seen, one of the great advantages of arbitrations is that you can select decision makers that have industry specific knowledge and experience. Have you seen in the fintech space or crypto space parties taking advantage of that and being more specific about who the decision maker should be and defining that in the clauses?
Yes, certainly. I've actually started to see that increasingly because, of course, parties want to be able to take advantage of the increased level of control that type of drafting would offer them, and to ensure that they have confidence in an outcome that they can trust as being fair and reasonable.
That's interesting, and I have seen sort of experts form a panel, obviously, in various disciplines, not just crypto. But it is in its nature, the difference between that and a court process is a court will listen to an expert usually, if it's that specialist an area. The idea in arbitration would be the expert is the arbitrator, right? And hopefully, but in an ideal world, that's not a sole arbitrator, because great experts don't necessarily make great arbitrators, right? Great judges don't make great experts, right? It's safety in numbers, and that I think does make a lot of sense.
Yeah, I think it's really a matter of having an arbitrator who can understand, if not all of the technology, at least understand the experts that are in the case. Because really, sometimes you're going to put an expert in front of a judge who's never thought about technology issues, particularly crypto or blockchain issues, and they're just completely lost. They're starting from ground zero. But if you have an arbitrator who has some specialized expertise, and as Sarah knows, at the Silicon Valley Center, we have a list of arbitrators that work at, on behalf of institutions around the world to sort of provide their knowledge. But I think they largely work in conjunction with the parties' experts to come up with the right result.
Yeah.
And as you say, Mark, there's always safety in numbers.
Yeah.
So having a panel of arbitrators is always, I think, a safe path forward.
Certainly, if the amount in controversy justifies it, indeed, it's preferable. Other bells and whistles that you're seeing included in these clauses before I hand it back to Shan to talk about the particular types of claims we're seeing in the fintech and crypto space?
But one of the things I've seen, sorry, I'm not sure if it will qualify as a sort of bells and whistles, but you know, a sort of multi-tiered dispute resolution mechanism where parties are kind of expressly putting their minds to a progressive approach to dispute resolution. So starting first with mediation and then looking into arbitration, you know, with a view of taking the, you know, the most effective path forward without, you know, going, you know, full out at the outset. So that's one of the things that I am actually seeing as well, where parties are taking a sort of progressive approach to dispute resolution, and that being built into the clauses in contracts.
I've seen provided for, though not seen in dispute context, an on-chain, off-chain approach to the application of terms and conditions. So one of the key leverage points in any litigation, any dispute resolution, is I'm going to stop your business until we resolve this effectively. I'm going to get an injunction. It's going to cause you a lot of pain. Why don't you settle it now? Okay, and that's the sort of thing I say to people, and it's the traditional way in court. Right? I've seen this process by which you can park some of the dispute, on-chain part of the dispute, and say, right, we'll put that over there, or we'll take the off-chain stuff and we'll deal with it there, but we get to continue in the meantime. There's a reference in a case, though I don't know too much about fork. You know, you can fork off and deal with part of a whole area of dispute. I think that's quite interesting. If it's possible to work it, great. The other thing is, you mentioned earlier class action, right? You know, it's a very new area in the UK. It's non-existent in the BVI, but the whole idea of multiple actions being consolidated, when you're in consumer arena where you have a lot of people wanting to say the same thing, and you might, I don't know enough about it in the US, but you might say that was fertile territory for a class action against whatever, one of the big platforms. Some of the arbitration rules allow for the idea that you can start 10 of them and get them heard together, or get one heard and the parties agree the issues resolved will apply to all 10. You know? And so consolidation is, I think, an important aspect to a B2C, a consumer type contract, because if that's available, that might encourage, it will lead to ambulance chasers, crypto chasers. But I suspect, and that's where, you know, confidentiality comes in again, but I suspect people will like the idea that they can be one of many, and it can be, you know, tested out and resolved quite quickly.
Fair. With that, Shan, I'll hand it back to you. I know you wanted to also cover the types of claims that you're seeing in this space.
Yeah, Sarah, and I think I wanted to focus more on because we've seen an uptick in liquidation and fraud disputes in the fintech industry. And Mark, if I can sort of get your views from a BVI perspective, do you think our arbitration clause is wide enough to cover fraud disputes? And in terms of the BVI courts, are they able to assist in terms of enforcing arbitral awards in crypto assets? And what's been their general attitude towards that?
So yes, I would suggest probably most referral to arbitration clauses would permit any, if you like, dispute between the company and parties, and that would include fraud. There's no reason why not. Bankruptcy and insolvency is a very different thing. We don't get English precedents very clear in this. You don't get to, no arbitrator gets the power to wind up a company. That's a different jurisdiction. We call it the jurisdiction of the company's court, right? But it is different. But the dispute that leads to the relief may be arbitrable. And you would any court action would be stayed pending the underlying dispute to be dealt with by the arbitration mechanism. And then the arbitration comes out, finds facts, finds liability, if you like, and then you go back to court and say, these are the findings of fact, I want the company wound up. Now, as I alluded to earlier, here, there is a process in most jurisdictions, I would imagine, that I don't want to wait for a dispute. I don't want to hear your defense because it's so obviously you don't have a defense. Here's my debt. You haven't paid it. You're clearly insolvent. I issue an application to wind you up because the liquidator is going to go and rip you apart and give me back my money. Right? That's the nuclear option. Right? Now, it's so nuclear that in our court system, if you misuse that and there's the slightest hint of a credible defense to the debt, you will not only be dismissed on an abusive process point, you'll be paying all the costs and all the rest of it. What's interesting about that is that our courts here have interpreted on the arbitrability point that if there's an arbitration clause, even if you have a clear debt, it is, unless you are prepared to go to the wall and say there is no defense to this whatsoever, if there is any hint of a defense, then the winding up process still can't be heard. Even though you can establish beyond all doubt, it still can't be heard. You have to go into the arbitration to resolve it and then come back again. Now, that's, it's very safe and it can be quick. And you can go off and convene an arbitration very quickly, come back and say, please wind up the company. So in terms of you're touching there on arbitrability, on scope within the clause, on whether or not, the rules of any particular institution will allow you to do that. I don't know of any rules that allow jurisdiction to wind up a company, but certainly most fraud disputes would be available to be determined by the panel. We see here in the BVI disputes between companies and shareholders in, as you can imagine, their holding company jurisdiction in the hundreds of millions of dollars, billions of dollars in any one dispute. It could be subject to arbitration. There's no reason why not, and it might go off somewhere else to do it, or it might go in the BVI. But it regularly can face an arbitration clause.
Yeah. And Tara, from the Barbados perspective, what has been your experience? Are there scenarios where certain disputes with respect to liquidation where judges will refer those matters to arbitration?
I would, kind of concur with what Mark is saying, because, if the issue is one where the substantive matter that actually gives rise to liquidation is subject to arbitration, one would be encouraged or guided to seek arbitration as the first point of resolution, and then to resort to the courts in the context of liquidation. So it's a sort of parallel procedure that would occur here in Barbados.
Good. And Gary, what's the Americans' perspective?
So specifically with respect to liquidation, I think we have a fairly clear divide between the jurisdiction of the U.S. bankruptcy courts and arbitration. And the bankruptcy courts really do jump in and cover most of those issues. If there are, from time to time, there'll be arbitration agreements, and the courts may allow those arbitrations to proceed to resolve particular issues. But I think, to perhaps answer the broader question about where is arbitration in fintech being used, I think if you're going to see a lot more in the Caribbean beyond these liquidation type disputes, because there's just so many cases coming. So, we've talked about the consumer and also the business to business cryptocurrency disputes, but with all the new companies that are forming in your region, I think you should expect to see the wide range of disputes that they generate, be it disputes involving finance software, infrastructure, technology, real estate related crypto and other fintech disputes, insurance related disputes, alternative lending. I think there's going to be a real new sort of wave of disputes that are ripe for arbitration.
And with that, something, Shan, you alluded to earlier, is the necessary ability of the local courts to assist the arbitration process. Right? You see it in most jurisdictions, certainly in the BVI, the power under the Arbitration Act to not necessarily use the tribunal to give you an interim relief, such as an injunction to do something, but to go in secret if necessary to the court the court of the jurisdiction and say, I need this injunction. Can you give me it to assist the arbitration that's currently in the jurisdiction? And we often, I mean, in fact, not that long ago, we dealt with a very large injunction in the BVI to assist a Californian arbitration, not a Silicon Valley arbitration, but a Californian one. And we're talking $600-700 million, right? Where the BVI court assisted that with aid of an injunction, and that's becoming more common. There are one or two very well established rules and arbitration centres that will require you to have permission of the panel, the arbitration panel, before you can go to court. That strikes me, the whole point of emergency and secret relief. But if you can justify secret relief because something's being moved around, as we did, the court will hear you. I understand entirely, is particularly in the US context, the idea of ex parte going in secret is completely foreign to the notion of how proceedings are conducted. But where you can justify it, because it's going to happen, and it will happen if you tell them, then that is very available in our jurisdiction. You obviously have to come back to court after you've served your order, but by that stage you've stopped what it is they're going to do, and you pay the consequences if you get it wrong, right? But it is available.
Yeah, you're absolutely right, Mark. I mean, in the U.S., I mean, we do have the ability to get TROs from the court, to get emergency arbitrators. But I think what your point really goes to is much broader than that, and that is the cooperation between the courts and arbitration tribunals around the world. And it's not as if we're really talking about one versus the other. It's really the ability to get the best results that you can by using both arbitration and the courts hand in hand.
Yeah, no, that's a fair point. Now, I know we're nearing close to the end of our webinar, and I want to give our participants a chance to ask questions. And I think we have a few, so I'm going to hand over to Sarah. So if you can, to the questions that we have.
Sure, I think we have time for one or two before we thank our panelists and welcome everybody to their weekend. But so one question that came in was whether or not we can use FinTech arbitration to solve I assume, disputes related to smart contracts in the construction industry. Most arbitral institutions don't have FinTech specific rules, though many do have construction specific rules. And I suspect that either route would be compatible with resolving those types of disputes. But interested to hear if the panelists have other thoughts.
And this is in fact a timely question, Sarah, because we are soon going to be launching our construction arbitration panel, and certainly I know smart contracts is becoming very important. So I think that's something that we need to look at and keep in mind as well.
For my part, the short answer is yes. I mean, if you look at the UK jurisdiction task force, which all sounds very impressive, but they came up with the digital dispute resolution rules, which were quite innovative not long ago, but they were designed for all aspects of FinTech, including smart contracts. Where they went slightly perhaps overboard is what I referred to earlier about the ability to give the arbitrator the chance to enforce before you could go through any other process. That's in those rules. But no reason, I don't think at all, why you shouldn't apply smart contracts to construction business. Maybe I'm wrong, Tara, I don't know.
Yeah, I think it works fine. I'm reading the question again, what I'm guessing that the questioner is asking about is, the automated provisions of the smart contract in terms of enforcing, the outcome of it. And I think the answer is yes. I mean, certainly arbitrators, can go ahead and issue an award that will implement the decision. And as you were talking about earlier, Mark, I mean, it's going to depend, I think, from jurisdiction to jurisdiction, how that actually gets implemented. And you all would know better than me on the BVI and the Caribbean procedures, but it sounds like you have quite an ability to really assist companies there in enforcing the smart contract provisions.
Sure. So the only pause that I would kind of draw right there is to the point that you had made earlier, Mark, as to whether or not there could be any issues or challenges that could arise subsequently in relation to the arbitral award itself, and having that arbitral award be executed by way of a smart contract and sort of that being a fait accompli. And that being a fait accompli, particularly in the context of crypto, unraveling that and trying to get parties to comply with that. I mean, you could, of course, get a court order compelling someone, if you can identify a wallet addressed to a particular individual or person to do a particular thing, but you wouldn't want to have to go that far down the road. And so this is a thing that I am somewhat concerned about when I think about on-chain arbitration which really revolves around utilizing smart contracts to actually execute an arbitral award, are those types of issues where an award is subsequently challenged and has to be unraveled, and the complications that would arise in that context. So naturally, of course, it could be relevant and applicable to the construction industry, but there are legitimate issues that one would have to be careful of. And I think we will increasingly see those issues being ventilated as the use of arbitration in these types of disputes proliferate.
Mm-hmm.
I mean, it really is case specific, right? I mean, smart contracts in and of themselves are self-executing. So you have to look at the particulars of the contract in this case to determine how it exactly would work in interplay with arbitration. But I think the general answer is, I mean, arbitration is perfectly suited for construction industry and fintech, and I think they could work well together.
Yes, and it would be a lot cleaner than concrete boots if you get it wrong. So that's
I think we are at time.
Yeah, so I'll take this opportunity to thank our speakers for participating and providing some great insight into the fintech industry. I'd also like to thank our participants for attending. We will have a recording, and so when we have that, we'll be sure to send a copy, and we invite you to subscribe to our email list so you can get more information. We'll be sending information about both centers in a follow-up email so that you can have information about both centers as well as both arbitration weeks. So again, thanks to our speakers, and everyone enjoy your weekend.
Thanks all.
Bye.
It was a pleasure.